Hello, this is Tim Bird. I'm a corporate partner in Field Fisher's corporate department, and today I want to talk to you about the impact of COVID-19 on mergers and acquisitions. With most businesses globally currently in survival mode, it might seem a strange time to be talking about M&A. Staff have been furloughed, been asked to take sabbaticals, unpaid leave, or accept reduced hours or pay, and for many companies, M&A is far from their minds. However, we're now 5 weeks into lockdown in the UK and longer still in other territories. And whilst it may be too early to be talking about M&A opportunities for some companies with strong balance sheets are starting to look at what the landscape will look like for minority investing and acquisitions in the near future. Also, other companies are sadly going to be forced to seek an early exit or down round funding to get them through the rest of the year. I saw a figure just yesterday suggesting that a huge proportion of UK startups have funding that will expire within the next 12 months. So with that in mind, the question many investment professionals are asking is what impact the post-COVID environment will have on the process of M&A. So I thought it might be helpful to explore some of the conversations we've been having and to share the latest thinking. What is clear is that for those companies wishing to embark on an exit or seek funding, the process is likely to take a lot longer than we've got used to in recent years. So what can we expect? Well, valuations will be the first challenge and probably one of the main ones. Can you rely on last year's P&L as a good indicator of next year's profit? Are there any reliable multiples for a particular sector? The discounted cash flow forecast, or DCF, used to be the most frequently used valuation methodology. DCFs rely upon historical analysis and projecting cash flows forwards to provide the equity value of an asset. So for a DCF to be meaningful, you need some up-to-date cash flows for at least a period of historical time, as well as a reasonable prediction of growth rate. And we currently only have one whole month of data for revenues and cash flow post-lockdown in the UK, and any prediction about growth rate is likely to be guesswork at this stage. Similarly with comparable company analyses, or comps as they're often known, these are also likely to be less relevant right now, either as they rely upon industry or peer group standard multiples, and it may take a while to have realistic valuations for other similar companies, with current data effectively freezing the valuation in the pre-COVID era. So as a result, there are going to be some large discussions or even arguments about valuation, and the strength of the bargaining position is likely to be the major determining factor in who wins the battle in each transaction. It will undoubtedly take a while until sellers become more realistic about the current value of their business, and we saw that last in the 2008 financial crisis. Once you've established a valuation for both parties that you're happy with, due diligence is the next step in the process. We've been recently working with Hemsley Wynne Furlong LLP, the warranty and indemnity insurance brokers, on a couple of transactions where there was a need for a W&I policy. Their up-to-date view from W&I underwriters is that due diligence is going to take a lot longer and will need a lot more detail if parties to a transaction want W&I cover. Their article on COVID-19 and W&I insurance is well worth a read on this subject. So in terms of DD, the key areas which will need much more investigation now on an enhanced basis include the following. Firstly, employment issues has got to be head at the top of the list. With guidance implementation given by governments and international bodies, has the target considered and implemented the directions contained in such guidance issued on employment matters as a consequence of the pandemic? Examples of these are getting your workplace ready for COVID-19, which was issued by the World Health Organization, and COVID-19 guidance for employees, employers, and businesses, which is issued by the UK government. Pay or paid leave. Has the employer complied with the payment obligations introduced in some cases to protect employees from the effects of COVID-19 on their work arrangements, such as statutory sick pay, payments due under layoff periods, etc.? Dismissals and redundancies. Have relevant procedures been adequately adhered to where applicable? Where there's any doubt, buyers are likely to want to make this the seller's risk. Health and safety. We've seen just this week unions advising employees in the UK to push their employers where they have a duty of care not to put employees in harm's way. Is the target's business one where people come into contact with other people? If so, should PPE be available as a matter of course for employees? Second area of importance is material contracts. Whilst it is standard procedure to review all material contracts in a DD exercise, it's a slightly different process when checking whether COVID-19 has affected supplier or customer relationships or the performance of contractual obligations. So be sure to investigate termination rights, limitations on liabilities, costs, change in law, and change of control provisions. There's been a lot of talk recently about force majeure clauses because in many cases it will be difficult or impossible for businesses to perform contracts which were entered into before the onset of the pandemic. Force majeure clauses are agreements between parties that their contract may be varied or suspended in certain extreme circumstances. The enforceability of a force majeure clause will depend upon the wording and the context, and the party seeking to rely upon the clause will have to prove that the current pandemic falls within the scope of the provision. Does the clause expressly talk about epidemics or pandemics or something along these lines, or is there broad sweep-up language which could be relied upon? Does the clause talk about preventing or merely hindering or delaying, which is clearly weaker? It will also be important for the parties seeking reliance to show that they have taken reasonable steps to mitigate the impact of COVID-19 on the contract. It will be hard to show that a problem caused by the pandemic was beyond the control if they could have taken steps to resolve it. It will be hard to rely on COVID if there is another obvious reason why the contract was not performed. Notice provisions. Have all notice obligations been satisfied under the contract? Limitations on liability. Has the target's liability or ability to recover against a counterparty been assessed in every instance? Non-performance and termination rights. Has the non-performance by a party given rise to a termination right? Then you need to think about general principles of law such as frustration. Where you cannot rely upon a force majeure clause, it may be possible to argue that a contract's performance has been rendered impossible to perform in the circumstances. Is the commercial purpose of the contract no longer achievable? Delay caused by COVID could render a contract frustrated, depending upon the nature of the contract and the length of the delay. If the government passes legislation which would render performance of the contract illegal, that would assist in the argument of frustration. And finally, renegotiation. This quite often happens with the terms of a contract will be varied by renegotiation, which is set out in emails or even oral discussions. So if there's a risk this might have happened, you'll want to include a warranty to that effect and expressly ask the question during due diligence. Number 3, data privacy and cybersecurity. With a large number of remote workers operating over new and often unsecure platforms such as the free version of Zoom, you will need to check that targets have put in place adequate measures to ensure the integrity of the IT systems during home working, including the protection of personal data processed by the target. Have the target's data protection notices and records been updated? Have government guidances been adhered to, such as that in respect of employees, workers or contractors who have been diagnosed with COVID-19? Also, some organisations will fall within the notification to organisations to share information to support efforts against coronavirus. So that should all be looked at. Number 4, valuation. I mentioned valuation methodologies earlier, but they will also be important for W&I insurers when trying to establish the amount of loss recoverable under the policy in the case of a claim. What was the valuation and what assumptions were made when using the method? How was the impact of COVID-19 factored into the valuation? You will need to show that you looked at, firstly, the size of the impact and length of time such impact has had and is expected to have on the target. and also the treatment of debts and how easily these will be able to be turned into cash. What cost savings and deferrals could be made in mitigation, and what help the government is providing to the target. Number 5, the consideration structure. I'll talk about this in more detail below, but it goes hand in hand with the valuation. Number 6, tax. Maintenance of tax residency. Where have board meetings taken place, and were a sufficient number of directors able to attend in person to argue management, operation and control remained in the jurisdiction of tax residents? With people working from home, it will be easy to bring operation and control onshore for offshore companies. Creation of permanent establishment. Again, where key workers have returned home for lockdown, has their remote working created a permanent establishment? Number 7, finance and credit facilities. Take extra care with distressed targets. There's an enhanced insolvency risk. The triggering of covenants can cause an event of default or a risk of cross default. Number 8, third-party consents. When there are leases or bank loans in place, you'll need to talk to landlords and banks. And landlords or banks will clearly worry about the covenant strength of the acquirer. With staff working remotely, that's one factor, but there's a lot of nervousness, meaning that decisions take longer in the current market. Similarly, with change of control provisions, if you're going to have to obtain consent to the change of control from a material customer or supplier, make sure you allow plenty of time for those discussions. And finally, number 9, our experience has been that regulatory bodies are taking longer now than ever. So make sure that you allow yourself plenty of time to talk with merger control regulators, for example. That may require you to allow a greater degree of time in the period between sign and close. So you might need to think about what provisions you've got in that intervening period. Next, I wanted to talk for a few minutes about other things to look out for in SPAs or sale and purchase agreements. As I said earlier, consideration structures. As mentioned above, a lot more thought will need to go into consideration structures going forwards. Where at one time some sellers may have seen earnouts as something that rarely got paid and was frankly a nice to have, now these and deferred consideration will become the norm and form a much more material part of consideration payable, in which case sellers will negotiate these clauses a lot harder and want to make sure there's no possibility of restructuring post-completion in a way which will risk the target's ability to account for any revenues or profit upon which the earnout will be based. Risk for breach of warranty and indemnities. Make sure there is clarity about limitations on liability. Sometimes we will leave that discussion on the buy side until sellers are committed and have started incurring costs, and you've really got into the proper negotiation. But if you're considering an exit, you will want to discuss that up front at term sheet stage. Buyers will seek to push a lot more risk onto sellers in the form of indemnities at the moment, and that's something you need to bear in mind. Just 2 more practical considerations when it comes to the impact of remote working on signing and closing. So let's talk about virtual signings and closings. We've all been working on virtual signings for years, but many law firms have not until relatively recently started to use DocuSign in earnesty. We've been using DocuSign ourselves for contracts underhand for a long time, but only recently started using it for the execution of deeds where a proper witnessing protocol had been agreed, as the SRA has not agreed that we could rely on DocuSign in every case. So make sure the law firms involved have a premium version of DocuSign. And we want to see these days IP addresses being tracked where possible to ensure that the witness and the signatory are physically proximate. Now, I understand that may be difficult with social distancing, but it's something to be borne in mind. And there may be some other practical ways around it, but it needs to be discussed ahead of signing. Final point I would make is to say that with regard to funds flow, at closing. Where you're working on a cross-border transaction, it's well worth a dress rehearsal among lawyers and signatories so that all parties and advisors know what to expect. With bankers working remotely, you're likely to have less time each working day to move funds, and it's well worth discussing what all parties can expect. Can you use solicitors' undertakings to enable close? That was something we had to discuss recently in a cross-border transaction where the parties were not familiar with the use in the UK of solicitors' undertakings. So take care if you're hoping to rely on those. So that was my summary of the key impacts of COVID-19 on M&A. But if you're either contemplating an acquisition or a minority investment, or an exit or funding round, do give us a call, as it really does help to get your ducks in a row rather than being caught unprepared at the point a transaction kicks off. We would be delighted to talk things through. Many thanks for listening.